Well, hello everyone, and welcome once again to this live stream session. Welcome to your employment law live stream session. I'm your host, Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and you're here waiting and to listen more and to understand and learn more about employment law. This is where you get your answers or your questions answered when it comes to everything to do workplace rights, employment law, your job, your compensation. So I'm Lior Samfiru again, the employment lawyer. You can find my firm Samfiru Tumarkin across Ontario, BC, and Alberta. And what we do is we help individuals with their workplace rights. We help you understand what those rights are. And of course, we help you enforce those rights. And on this live stream, what I do is I log on here so that you have an opportunity to ask questions and learn and get some answers about employment law. If you want to know if your boss is doing something illegal or illegal, if you want to know if you've been wrongfully dismissed or constructively dismissed, or what to do about bullying or harassment, you name it, this is the time and place to get some answers and help. There's no better way than just type in your question, hit enter, and I will answer that question. I see questions have just come in, and I will start answering them in a moment. Before I start answering questions, I want to also give you some additional contact information. If you want to connect with me and my team off air, if you want to get all our contact information, so very easy to do. All you have to do is go to employmentlawyer.ca. You see that address over here, employmentlawyer.ca. And when you go there, you'll get all the contact information. You can fill out a form if you prefer, and we'll call you. And of course, you can also learn and read a lot more about employment law. Again, employmentlawyer.ca. But right now, myself, Lior Samfiru, the employment lawyer, I'm here live with you answering questions. Remember, there's no bad questions. There's really only answers. There's solutions. There's things that you can do right now to make your life, your work life at least, better. And it starts by answering or asking me a question right now. I'm going to start answering questions. Type in your question. Don't just sit there and wait on the sidelines. Make sure you get the help that you need right here with me, the employment lawyer, Lior Samfiru. First question today comes from Kenoki F1, non-unionized in BC, has been working 15 years for my current employer. After return from 4-week stress leave, my boss asked me to complete a tracking sheet for all things at work, for all things I did at work for every 15 minutes. Is it reasonable? So if it's something that they're doing across the board, it's not illegal. And it's, again, the question is never whether something is reasonable. The question is whether something is legal. And it's not something that is illegal if they're doing it across the board. On the other hand, if they're picking on you because you had a medical issue, that's different. That could be a human rights violation. That may be inappropriate. So again, across the board, they decided from now on, we just are going to track everyone. We're going to be overseeing everyone. So you have to do it as well. Not nice, not even reasonable, but also not illegal. But if they're picking on you, that could be a human rights violation potentially, if the only reason they're doing that is because you were off on a medical leave. So if you think that this is what's happening, if it's a discrimination issue, let me know. I can help you. I can either get them to back off. If you prefer, there's potentially human rights damages to pursue as well. So that's really what it comes down to. Are they picking on you because of your medical condition, or is there something that they're implementing across the board? If you have any follow-up questions, you can ask them right now. Otherwise, to connect with me and my team, again, very easy to do. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. Thank you for that. Great question. Sorry you're dealing with that, but you know what to do. You can reach me at employmentlawyer.ca. See how easy it is? If you're just joining, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, and you're on my live stream session where I get to answer your questions about employment law, workplace rights, everything to do with the law at work. That was our first question today. Ask yours as well. Keep me busy. Keep me on my toes. And I'll continue answering questions. Next questions is from Bonnie. My assistant store manager told me they can't accommodate my disability anymore and said I should either switch to a day shift or go on short-term disability. I explained that I can't work days due to family responsibilities, and I was hired for the night shift. I have a 10-pound lifting restriction due to a hernia, but there are still many lighter tasks I can do. I even offered to help in other ways, but I was ignored. They told me not to come in for the rest of the week. I'm in Ontario. I believe this violates my human rights. What are my options? Well, the answer here is fairly straightforward, Bonnie. If they are able to accommodate you, but they're choosing not to accommodate you, of course, that's illegal. That is a human rights violation. An employer has a very strict duty to provide accommodation if someone has a medical restriction or a medical limitation. And that is an accommodation to accommodate them as much as possible within their job, not a different job if possible. So if your employer has been accommodating you up until now, it shows that they're able to do it. If all of a sudden they say, well, now it's just too much, it's probably not legal. They would have to show that something major changed in order for them to be able to say, we were able to accommodate up until Monday, but now we can't accommodate anymore. So yeah, you're very likely looking here at a human rights violation. An employer should accommodate you. If you're able to do modified duties that meets your lifting restrictions, they have to accommodate that in the day shift. Now, if it turns out that they can't, they tried, they looked, that's just not possible, then they may have other options. They can offer you a different role, or if that doesn't exist, you can go off on a disability leave. But that only becomes an issue if they legitimately cannot accommodate, and that does not sound to be the case here. So as I was saying to our previous person here, Bonnie, reach out to me, okay? Let me help you deal with that. Once they hear from me, they'll back off, they'll accommodate, okay? You can reach me through employmentlawyer.ca. Again, employmentlawyer.ca. Of course, you can ask follow-up questions as well. So by all means, reach out, I'll help you. Again, I'm Lior Samfiru, the employment lawyer. If you've just joined and are wondering what is this thing all about, well, what it's about is that I answer your employment law and workplace questions. This is where you get the answers, the solutions, the real truth, not legalese, not complicated answers or explanations, just straightforward talk so that you can understand what your workplace rights are. I've answered a couple questions. I'm going to get to more right now, but don't just listen. Listening is good. You'll learn a lot. Even better, ask your question. All right, let's see. Next question is from Bisret Yosef, 1887. Sorry if I'm mispronouncing. I'm on LTD. I just passed 2 years. The insurance reduced the payment with no explanation, and my employer terminated on frustration of contract, and the employer said I'm not eligible for any payments. Any comments on those? Is there any action I need to do? So let's deal with the disability insurer. Now, the insurance company can't reduce your payments unless the insurance policy allows them to do that, or because you've received payments somewhere else. They can't just say, hey, we want to pay you less. So right off the bat, we need to deal with that, okay? If the insurance company is not paying you what they're supposed to, once they hear from us, they'll pay you. The other issue is this idea of frustration of contract. Your employer can let you go for frustration of contract only if it's clear that you will never be able to come back to work again. So if your doctor is saying you can't come back anymore, that's it, it's over, doesn't matter, you're not coming back ever, that may be frustration of contract. You still have entitlements, you're still owed something, but it's not going to be much, okay? You're still going to be owed your minimum entitlements under employment standards, but not your full entitlements. On the other hand, if it's not clear yet whether you will or you will not be able to come back to work at some point in the future, they cannot let go for frustration. And if they let you go, they owe you full severance and potentially human rights damages as well. So there's a lot we need to discuss here. So what I want you to do is I want you to connect with me through employmentlawyer.ca so I can help you. I want to obviously find out more about your condition, about what the insurance company has said, so I can help you, and my team can help you on both fronts, dealing with the disability insurer, as well as, of course, dealing with your employer. So again, you reach me through employmentlawyer.ca. Again, employmentlawyer.ca. Thank you for that. Great question. I'm sure you're dealing with that difficult situation. The good news is, of course, there is help. I got your back. My team's got your back. All you have to do is reach us through employmentlawyer.ca. Thank you for that. Fantastic questions, everyone. If you're just joining, I'm Lior Samfiru, the employment lawyer with Samfiru, Tumarkin, LLP. And you got time. You got time to still ask your questions right now. Plenty of time. So type them in. Don't let this session end without you asking me a question and getting an answer from me. Take advantage. I'm here for you. Ask the question. All right, next question today on YouTube from Ali. I'm a veterinarian in Canada nearing the end of my maternity leave, and I'm starting to suspect that my current role may not be available to me when I return. I was originally hired for one position, but moved to a different department and role before my leave, though that change was never formally documented. Now it seems my employer may put me back in my original role, which I wasn't very happy in, and I'm wondering if I have any legal protection or recourse, even though the role change was only agreed to verbally. So your employer's obligation is to put you back in the same position, same role that you had before you started your leave. So not the role you had a year before that, but the role that you had before you started your leave. If they don't do that, that could be, of course, an employment standards violation. It could even be potentially a human rights violation. It's not legal. So your job is protected for the extension or for the duration of your parental leave. Same job, same pay, same hours, same everything you had before the leave. So if your employer is giving you a different job, not legal. But as I was saying to our previous individual there, once they hear from me, see how things change so very fast. Yeah, of course we can do it. No problem. It's just a big misunderstanding. So you want to reach out to me, let me write to them and tell them, hey, no, can't do that. They'll back off. They'll do the right thing. Okay, so Ali, reach me. Let's do this as soon as possible because you said your leave is almost ending. You can reach me through employmentlawyer.ca. Again, employmentlawyer.ca. See that address on the screen? Take advantage, use it, contact me, let me help you, let me get those issues resolved. And oftentimes you may try to resolve a matter with your employer. Your employer says, no, they're not budging. Well, the big way to change that is let me deal with it. Once they hear from me, what do you think they're going to say? No, we're right. No, because if they're wrong and I'm calling them on it, they'll back off, and they'll back off so quickly your head will spin. So let me do what I do. Let me deal with that. Again, reach me through employmentlawyer.ca. But right now, I am still live here with you guys. Come on, ask questions. I know you have them because I deal with them all the time. Keep me busy here. Keep me on my toes. I see more questions have come in. I'm going to continue answering. Let's see. Omar has a question. Can my employer monitor my personal emails or social media activity if I use the company Wi-Fi? No. If you were using a company computer, then yes. I don't believe that just because you're using someone's Wi-Fi, they can monitor what you're doing. I could be wrong. But if you're using a company computer, they can monitor anything that's being done on that computer. Okay. If you're using your own computer, just connecting to an employer's Wi-Fi, then no, there will be a breach of your privacy, I should say, to monitor what you do or your personal work on your computer. Okay. So there's the answer for that. Let's see. Serena has our next question on Reddit. My manager keeps scheduling me during religious holidays, even though I asked for those days off. Is that discrimination? Yeah, it could easily be a human rights violation. But here's what I want you to do. So I don't know what religion we're talking about, if you're a Christian or Muslim or Jewish, but whatever that religion is, get a minister or whoever the religious leader is within your group to write a note to your employer saying that you follow that religion and you follow those holidays and you're not able to work on those holidays. So rather than you saying that, I want that to come from the minister, the reverend, the rabbi, whoever the right person is in your religion. Give that to them in writing. At that point, they absolutely have to accommodate you by not scheduling you during your religious holidays. If they do that anyway, again, they'll back off as soon as they hear from me. Okay, very, very quickly. But I do want you to get that note from that religious person in your religion, whether it's in your church or your synagogue or ministry. So do that. Okay, provide them that note. Should be a 1 or 2 liner, very, very simple, and that should do it. If not, hey, I'm here. You reach me through employmentlawyer.ca. Again, employmentlawyer.ca. By the way, if you're now joining us for the last 15 minutes or so, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, with you, for you, at your service, answering questions, helping you understand your workplace rights. So take advantage of me being here, okay? And hey, let's continue answering some questions. Brobro D2M has our next question. I was working remotely for almost 2.5 years. Now, my company is trying to tell us to come back to the office 4 days a week. What do I do? Okay, so here's what you do. If you refuse, you can't be fired for cause. That's not job abandonment. So if you refuse, one of two things will happen. Either they'll back off and leave you alone to work remotely. That's option one. Or option two is they'll terminate your employment without cause. Remember, an employer is allowed to terminate employment without cause for any reason, pretty much, as long as severance is paid. So could they say, well, because you're not coming in 4 days a week, we're going to let you go and pay you your full severance? Yes, they can do that, because an employer could do that for any reason. So that's what it's at stake here. You ultimately have to decide, will they let you go? And are you okay with that as long as you get your severance? Or if you're not, then I guess you have to come to go in the 4 days a week. Of course, you can also negotiate with them and say, well, how about I only do 2 days or 3 days or 1 day, and see if there's a middle ground there. But ultimately, if they draw the line in the sand, remember, if you don't go, it's not abandonment. They may tell you, by the way, if you don't come in, you've abandoned your job, you've resigned. Nonsense. That's not the case at all. They will have to pay your full severance, and depending how long you've worked there, that could be as much as 24 months pay. If ultimately you lose your job because of this, I want you to call me right away, okay? Immediately. And you reach me and I'll get all the contact information through employmentlawyer.ca, over there, employmentlawyer.ca. All right, thank you for that. Great question, obviously. And now you know what to do. Reach me if you lose your job, of course. All right, let's see. Question from next question is on Instagram from Marcus. Can I get fired for talking about my salary with coworkers? So could you be let go without cause? Yes, you can. Could you be fired with no severance? The answer to that is no. You cannot, because it's not really considered any form of misconduct. Okay, so as long as they pay severance, remember what I said earlier. Yeah, generally they can let you go. So ultimately, that's the consideration there. Okay, let's see. Next question from Chloe on Reddit. My company just changed our vacation policy and took away days I'd already accrued. Can they do that retroactively? So they changed our vacation days and took days. No, okay, so fantastic question. If you've accrued certain days and carried them over pursuant to our policy, they cannot take that back. No. They can say from now on, we're going to change the rules on how you accrue days or how you carry over days. Sure, they can do that. But what they can't say is, we've decided you lose those days. Now, if they had a policy previously saying if you don't take a certain amount of days, you lose them, that may be okay. But if they didn't, and now they've decided to change things retroactively, can't do that, okay? The company can't take away entitlements that you had that have already accrued. Okay, so not legal at all. For that, you can file a complaint with the Ministry of Labor or have me call you, but absolutely not something that they're allowed to do. So very good question. I'm sorry you're dealing with that, but now you know the answer. Again, and to reach me, my team, very easy to do, employmentlawyer.ca, the place to go. Now, before I continue, I see more questions have come in, and I want even more questions to come in. I want to give you another tool or access to another tool to know how much severance you're owed. I've already spoken a number of times today about severance and how much severance you're owed and when you're owed severance. But to find out how much you're owed, very easy to do. All you have to do is go to pocketemploymentlawyer.ca. Over there, pocketemploymentlawyer.ca. And when you're there, you just click on our severance calculator tool. That simple. You answer a few questions and it's going to calculate for you whether you're owed 2 months severance, 8 months, 24 months, or something else. It's easy to use. It takes seconds. And by the way, completely free. It's also very completely anonymous. You can't put in your name there or your phone number or the company's name. You don't put in any of that in there, okay? free and anonymous, pocketemploymentlawyer.ca, and you'll be surprised. If you think in your head, hey, I think I know how much severance I'm going to be owed if I lose my job, do me a favor. Go to pocketemploymentlawyer.ca, use the calculator. You'll be surprised. The vast majority of people have no clue how much severance the law actually provides for them. Okay? They always assume it's a lot less than what it really is. Okay? So pocketemploymentlawyer.ca, use the severance calculator. You should always do that, whether you're curious, whether you think you're about to lose your job, and certainly if you're staring at that termination letter with that severance offer, you got to go to pocketemploymentlawyer.ca and use that severance calculator. All right, fantastic questions today. Love it. Let's see, continuing to answer questions. By the way, guys, you still have time. Even though we're getting towards the last 8-9 minutes or so of our session, you got time still. It doesn't take long. Type in your question. It's going to pop up on my screen, and I'll answer it. That simple. Huron Cedo 1303. 28 years with my company, facing harassment and discrimination and targeted write-ups. GM plus 2 directors involved. Investigation started. What should I do now to protect myself? So first of all, you want, to the extent that there's an investigation, you want to make sure that you speak to the investigator and provide all the information. And I want you to follow up in writing. So you may speak with the investigator, but I want you to follow up in writing so that there's no misunderstanding, right? So that the investigator, the person investigating, cannot say, well, you didn't say this or you didn't say that. Any information that you have in writing that proves the harassment is very valuable. If you know of people that could be witnesses to the treatment that you're suffering from, tell the investigator about it. You should also speak with Joanne and Barbara because they'll know. Tell them about it. Beyond that, there's nothing that you need right now to do other than provide all the information, as much detail as possible, and follow up in writing. Now, if the results of the investigation is yes, you were mistreated and the company deals with that properly, fantastic. Life is good. If they don't deal with it properly or they don't believe you, we need to talk. That could potentially be a constructive dismissal. We will deal with that at that moment. But for now, you want to give the company the opportunity to properly investigate and deal with this, as long as, again, you cooperate, provide all the information, follow up in writing. Okay? If you have any issues, you know how to reach me. Employmentlawyer.ca is the way to do so. And certainly, if you feel that the company has not dealt with it properly when it's all said and done, we need to talk. Employmentlawyer.ca to do that. Thank you for that, and I look forward to connecting with you if you need me. By the way, for the last few minutes, if you're joining us, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP, live with you here, answering questions about employment law and workplace rights. Take advantage of me being here. Just like Andre, who asked the question. My employer moved me to a different branch 80 kilometers away with no discussion or pay increase. I have to commute 3 hours a day now. If I quit, would that count as voluntary resignation or constructive dismissal? So assuming that you're commuting three hours, but it was much less before, because if before it was 2.5 hours, now it's 3 hours, it's probably not illegal. But if before maybe it was 45 minutes or an hour, and now it's 3, that's a massive change, and that can absolutely be a constructive dismissal. The rule that I generally follow is that if the relocation means you're commuting more than an hour each way than you used to, we're talking constructive dismissal. That's a big change. That's a big difference. So yeah, you're looking at a constructive dismissal, and if that's what you're facing and you leave, that means the company's going to be owe you severance. Now, another factor here is how much advance notice you had. So for example, if they gave you 2 years notice, as an example, that this move is happening, you may not be owed much or maybe owed very little. But if this happened with fairly short notice, yeah, that could easily mean you're owed your full entitlement. So as I like to say, the devil's in the details. So I want you to connect with me and we can have that chat. Certainly, I don't want you to quit or do anything until we've spoken, okay? So Andre, you can reach me through employmentlawyer.ca. Phone numbers there, email addresses there, all the contact information you need is right there. So take advantage and use it. All right, let's see if we can get a couple more questions. You may be able to squeeze in your question at the last minute. I worked at a company for 5.5 years and was only offered 5 weeks of severance. Is that allowed? Well, I gave you a tool, right, to find out how much severance you're owed. Pocketemploymentlawyer.ca. The severance calculator tool is there, so you can find out. But I can tell you, I'm going to spoil it for you. You're owed a heck of a lot more than 5 weeks, okay? Depending on your age or position, it could be anywhere from 5 months to 12 months, okay? Now, obviously, the older you are or the more senior a position, the more you're going to be owed, but probably anywhere from 5 months to 12 months, not 5 weeks. So you've, by the way, I'm talking, if I didn't read the name properly, it's TE1U, TI1U. So you've been wrongfully dismissed, okay? A wrongful dismissal happens when you're let go and are not paid proper severance. So please check it out. And I want you to connect with me. The good news is we can get you your proper severance. It's not going to be hard. It's not going to take long, okay? To get your proper severance, to have me help you, let's make this happen right away. Again, reach me through employmentlawyer.ca. All the contact information is right there. I'm glad you asked. And by the way, pocketemploymentlawyer.ca, the severance calculator tool is right there. Okay, so do you monitor? Next question is from Lindy. Do you monitor this chat after you're done to ask more questions? Or how often do you do these live chats? So if you go to employmentlawyer.ca, you'll see the schedule for the live stream. Most days, there's someone doing a live stream, myself or one of my colleagues, Monday to Friday, usually. If you ask a question when we're not here, we may miss that question. But it's very easy. Either you ask us a question during live stream, even better, just contact us directly through employmentlawyer.ca. You don't even have to do it in this live stream. Just contact us directly. So I think these are the questions that we have for today. Guys, now that we're finishing the session, another reminder, just because I'm going to turn off live stream doesn't mean I'm going anywhere. Doesn't mean my team is going anywhere. We're still here for you. We're going to answer questions. We're going to help you. We're going to roll up our sleeves and get to work to enforce your legal entitlements. All you have to do is reach us through employmentlawyer.ca. I'll be back here very soon. My colleagues will be here. As I said, we usually do this Monday to Friday, but you don't even have to wait until Monday. You can reach us right now through employmentlawyer.ca. Guys, I'm Lior Samfiru, the employment lawyer with Samfiru Tumarkin LLP. This was my pleasure. It always is my pleasure to connect with you, to talk, to answer questions, and hopefully solve some problems. Have yourself a fantastic weekend. Thank you for your attention today, and we'll see you again very soon. Bye now.